Hi, welcome back. Here we are at week 6. We're going to continue our discussion on constitutional law. This week we're going to take it a step further and talk about due process. This will cover a number of our amendments that fall under constitutional law. You'll be finding this course material in Wong's Chapter 7. So what is due process and where do we find it in constitutional law? We find it under our 5th and 14th Amendment. Let's make sense of these because they are, while very similar, they apply to two different entities. Our Fifth Amendment was enacted in 1791, and many of you probably have heard this statement. It's the notion that no person shall be deprived of life, liberty, or property without the utilization of procedures which serve to protect and preserve the rights of individuals. It's important to note that the Fifth Amendment applies to the federal government and/or federal agencies. The 14th Amendment was amended sometime later in 1868. This applies to state actors. So therefore, states, in part, indicate, according to this due process, and the language in our Fifth Amendment that nor shall any state deprive a person of life, liberty, or property without due process, to serve, protect, and preserve the rights of individuals. We'll make sense of this, of how the Fifth Amendment works towards federal government and federal agencies, as well as how that due process works in our state actors. Hopefully by this point, we are connecting the notion that most of our sporting agencies indeed fall under that 14th Amendment. They would be state actors. We learned that last week. Depending upon the events of the case, due process could fall under minimum due process or maximum due process. That is, what is the severity of the issue being brought forward? If the severity of the issue is high, an individual receives maximum due process, and it requires the following elements: notice of a hearing, statement of charges, provision of an adversarial hearing, taped recording of the hearings, and clearly stated right to appeal. That minimum due process falls on the other side. Those typical items brought under minimum due process are less severe. Therefore, it only requires a statement of the specific violation, some notice of the sanctions that will be imposed, and an opportunity for the accused to comment on the action. So how much due process then is warranted, and how can we make sense of this? A lot of cases often fall somewhere in between, but the elusive concept helps us better understand then where due process, or how much rather, due process is warranted. The elusive concept considers the following components. What's the magnitude of the interest involved? What's the extent to which the requested procedures would reduce errors in decision making? What's the burden on administrative bodies to give the safeguards? What's the seriousness of the infraction? What's the possible consequences to individual in question and the degree of sanctions imposed? In general, the more a person has at stake, the more formal the due process requirements. Let's address two different due process doctrines. First, let's talk about procedural due process. Procedural due process is concerned with the procedures used to enforce a rule or regulation. Therefore, our big distinction between our two, procedural due process and substantive due process, is that substantive due process and procedural due process is that the person alleging violations of procedural due process aren't challenging the rule's content, but rather the way the rule was applied. Therefore, in procedural due processes suits, a person alleges that they were not given enough due process. Then that refers us back to what we previously just talked about. Therefore, how much due process does an individual receive? Someone who got a parking ticket, for example, would fall under that minimum due process we just talked about. On the other hand, an individual being charged with potentially a higher crime, such as murder, where the death penalty might be at stake, would receive maximum due process. So remember, in these two, procedural The individual is concerned with the process used to enforce the rule. On the other side is substantive due process. This is concerned with how fair the law is. All right, what does that mean? That process concerns the actual rule or regulation in place. Think substance of the rule. When an individual alleges a violation of substantive due process, that person is challenging the content and application of that content. Therefore, we have to recognize that our due process claims protect persons from unreasonable rules and regulations. And if the rule is unfair or arbitrary in either content or application, the rule then may indeed violate the due process of the Constitution. So let's make sure we have these straight. Procedural due process is concerned with the procedure, and then we go on to ask how much due process should they get, minimum or maximum? And that refers us back to some of our previous slides. The substantive due process is concerned with the substance of the rule and or law, and asks, was the rule fair and reasonable in the content and the execution of that regulation? Now that we have some due process basics, we're going to work towards applying this to sport. Before we do, I just want to provide a reminder that in order to have a successful due process claim, one has to be deprived of life, liberty, or property. Typically in the world of sport, we have to recognize there is no deprivation of life. So when we begin to apply this to sport, we are going to think about concerns of liberty and property. Due process as applied to sport typically surrounds issues of liberty and property. Under liberty, in general, our courts have ruled that there is no recognition of participation in sport as a liberty. The courts have repeatedly ruled that participation in sport is a privilege, and that's not only participation for athletes, but also coaches. Therefore, in order to successfully argue a liberty interest under a sport context, one has to be able to show that they suffered a stigma and or sometimes a stigma plus because of the action taken against them. Our two examples come from case law of Stanley versus Big 8 Conference and Lagos versus Modesto Schools. In both of these scenarios, we have a coach in question who was either fired or did not have their contract renewed. In both instances, the coach sued because they believed their due process and or liberty was hurt because these things damaged their reputation. The courts ultimately ruled, as I've already indicated, that in the most instances, sport participation is a liberty. And in this instance, they've applied this notion of liberty to coaching. Furthermore, the ruling went on to state that who is a good coach, is subject to debate. And there's no shame to lose one's job in such an argument. Therefore, it's not a privilege. It's not liberty, it's a privilege. Okay, let's talk about property then. How does this apply to sport? The courts have recognized property as all interest in which an individual could be deemed entitled. Therefore, one must prove more than expectations of property. So what are our examples of this? For high school athletes, they have to be able to prove more than exception of property interest. We're going to see this eventually when we begin to talk about drug testing. In addition, for college athletes, we can apply this in terms of scholarship. Therefore, if a college athlete has a scholarship revoked and they make a due process claim, it's important to note that maximum due process must be given under such a claim. Let's solidify a few more concepts around the 14th Amendment as we apply it to sport. Remember, the 14th Amendment is concerned with state actors. Therefore, the 14th Amendment guarantees that state actors will treat all of us equally and that we will indeed receive this equal protection under the law. It also ensures that we cannot be classified then treated differently based on our membership in a particular category or class. For this type of discrimination, we can think of it two ways under the 14th Amendment. There's de jure discrimination, and this is discrimination that's done by law. It exists anytime a law or policy has a discriminatory purpose, and therefore that law would be considered a discrimination and in violation of our due process rights of the 14th Amendment. De facto discrimination are those that exist when the policy or law lacks a discriminatory purpose, but the outcome is discriminatory. It's also important to recognize that anytime a state actor treats a class of people differently, they must be able to show that the disparity of treatment is rationally related to legitimate state interest. So, for example, I've provided one here that there are requirements that say a lifeguard must be 16 years of age. This is acceptable because it's a relation to a legitimate state interest of safety of its citizens. Think also about due process or fundamental rights under the 14th Amendment regarding voting, or maybe even operating a car, or maybe even enlisting for war. The state can prove then that they have a legitimate state interest of safety of citizens in those ways. So therefore, we can recognize that disparate treatment might be acceptable when the state is able to show or demonstrate a legitimate state interest. And actually, we do this often in a number of our laws. When applying the 14th Amendment, how much scrutiny should be given to the situation at hand? The courts have given us a framework for how then we can scrutinize the situation. Strict scrutiny is given to situations or classifications based on race or national origin or any classification linked to a fundamental right. Therefore, if a situation is brought regarding due process of the 14th Amendment based on race, national origin, or classification linked to a fundamental right, the state must demonstrate strict scrutiny. Therefore, the state must be able to demonstrate that the discrimination is necessary to achieve a compelling governmental interest. And notice the language, because it will progress or digress as we move across our scrutinies. Intermediate scrutiny applies discriminations based on gender, illegitimacy, and alienage. Therefore, in these instances, the government or state agency must show or demonstrate intermediate scrutiny. That is, the state discrimination must be substantially related to achieving an important governmental interest. Lastly, there's rational scrutiny, and this is the lowest standard. In these instances, it falls outside race, national origin, or any classification linked to a fundamental right. It falls outside gender, illegitimacy, and alienages. And in this instance, then, rational scrutiny is given. That is the lowest standard, and it requires only a rational basis for action. That is, a state actor must only show a rational basis for the action. When it comes to applying the 14th Amendment to sport, constitutional law has repeatedly been applied to issues of drug testing. This has happened at both the high school and collegiate level. We'll spend the remaining of our time of our lecture addressing drug testing. When applying the Constitution to drug testing, we have seen it evolve in three different ways. Some apply to last week's lecture and some to this week's lecture, all following under constitutional law. First, state action. Drug testing and state action have been a repeated issue, so please remember our professional sporting leagues do not fall under state actors. Therefore, professional sporting leagues can drug test without limits. On the other side, though, collegiate and interscholastic sports do fall under state action, and therefore drug testing policies fall under state action. Recall that from last week's lecture when determining whether an organization was indeed a state actor. Another issue is, did the athlete receive due process in the drug testing procedures? We'll see that play out in several of the next slides in our courts. Finally, equal protection. It is necessary to prove there are good reasons or rationale for singling out athletes for drug testing. And as we already know, this applies to athletes at the collegiate and interscholastic levels. Therefore, equal protection must be determined or sought at those collegiate and interscholastic levels. When considering drug testing in sport, the question of search and seizures has repeatedly been brought to the courts. And remember, this falls under our Fourth and/or 14th Amendment. These amendments offer security against being unreasonably searched and/or seizures. And therefore, we have to ask then, is a drug testing procedure an unreasonable search and seizure? It's important, though, that under our Fourth Amendment, we must balance the nature of this intrusion of unreasonable search and seizures versus the promotion of a legitimate government interest. And therefore, to determine whether this balance can be made between this nature of intrusion versus this promotion of legitimate government interest, consider three things: the nature of the privacy interest, the character of the intrusion, and the nature and immediacy of governmental concern. When we address our case law on the next several slides, you'll see these kind of three determinations played out as applied to drug testing. However, courts ruled in applying concepts of our Constitution to drug testing in interscholastic sports. Verona School District versus Acton gives us one of our main examples of how the courts have indeed applied this to interscholastic sports. In this instance, Verona School District randomly drug tested student athletes. Acton was a member of the high school football team, and he did not want to be drug tested just because he was indeed a student athlete. The courts ultimately ruled that in the case of interscholastic athletics, student athletes have diminished expectations of privacy. And this also comes into play in collegiate athletics. However, the state has to show that they have a compelling interest to drug test. That's that nature of governmental concern. And in this instance, the state is able to demonstrate that drug testing student athletes at the school sport level does indeed have a compelling interest for safety in the regards of the student athlete at a school sport level. Furthermore, this case brought out the fact that athletes already agree, specifically at the school sport level, to have a physical before being allowed to play. Therefore, there is a health interest involved in interscholastic athletics. So what does this mean? Ultimately, at the end of the day, school sport programs can legally drug test student athletes for safety reasons. How has our court systems addressed drug testing at intercollegiate levels? It's important to note that drug testing began at the NCAA in 1986, and for the most part, the NCAA requires student athletes to provide urine samples in order to be drug tested for performance-enhancing drugs. One of the first cases we saw came out on our right-hand side. It's our University of Colorado versus Durden. In addition to urine tests, those required by the NCAA, the University of Colorado had several of their own drug testing procedures, and Durden found them to be strict and invasive, and he didn't want to comply by them. Therefore, he filed a suit under our 14th Amendment stating that these were too intrusive. Ultimately, the Supreme Court ruled in favor of Durden, and they stated that the University of Colorado must do less intrusive testing or don't test at all. This is where then Hill versus the NCAA comes into play, and that's on our left-hand side. Hill was a swimmer at Stanford, and she did not want to be drug tested. And as I said prior, the NCAA typically requires a urine sample. The ruling then by the Supreme Court is that urine tests are not too intrusive for student athletes. So this mode of drug testing has proven to be acceptable according to the 14th Amendment. How does drug testing apply to our higher level sports? Hopefully we're starting to recognize and connect that our professional sporting leagues are not state actors. Therefore, this is not a constitutional issue. That is, drug testing across our professional leagues is actually an issue of employment. Why? Because they've collectively bargained with the leagues that drug testing is a condition of employment. Please think back to some of the things we discussed in week 5 regarding professional leagues as state actors and collective bargaining. Therefore, drug testing issues are handled between the players' associations and the leagues, and they're collectively bargained and agreed upon. Therefore, it's a term of employment. What about our Olympic sports? We've already talked and we addressed this last week. There's not a state action due to our worldwide emphasis, and oftentimes our decisions are made by Olympic committees outside the US. Therefore, Olympic drug testing doesn't fall under constitutional law. It's also important to note because of the nature of competition in our Olympic system, little time would be afforded for due process. Therefore, these are not constitutional issues. Okay, we find ourselves at the end of week 6. We've addressed due process under our 5th and 14th Amendment. We've also addressed how we're applying this to drug testing at our school sport level, our intercollegiate level, as well as our higher sport levels. That's it for this week. Have a good week, and I will plan on seeing you next week.